Welcome to the Probate Nation. My name is Richard Ruddy, and I'm the host of the show. Our show this evening is part 2 of a 2-part show providing an overview of the probate of an estate in the District of Columbia. Probate is a process to transfer the title or ownership of probate assets to the beneficiary of a deceased person. Not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on a slow-moving steam engine train, probate of an estate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets remaining are delivered to the decedent's beneficiaries. Some probate train rides are short, while other probates seem to never end. In order to start the probate journey, someone needs to be in charge of driving the probate train. The title conferred on that person is typically personal representative, and they may be named in a will or volunteer to serve if there is no will. Regardless, that person is not empowered to drive the probate train until they are legally appointed to do so. In part 1 of this show, we began a discussion of the nuts and bolts involved in probating an estate in the District of Columbia, including determining if the decedent died with a will or without a will, the importance of identifying beneficiaries of the estate, the types of probate available in D.C., the role of the D.C. Register of Wills, duties of the personal representative appointed to probate the estate, timelines and deadlines, and dealing with creditors. In our show this evening, we will complete the overview with a discussion on wrapping up the estate, fiduciary compensation, common problems encountered in administrating estate, the importance of getting advice from professionals, and then we're going to apply all that has been discussed to some typical probates. We are pleased to have back the guests from part 1 of this subject to complete the discussion of this topic. Our first guest is a probate and real estate attorney who practices in District of Columbia and Northern Virginia. He handles guardianships, conservatorships, wills, trusts, foreclosures, estate administration, and real property litigation matters. He's a member of the D.C. Superior Court Fiduciary Panel and accepts court appointments in guardianship and estate matters. Prior to practicing law, he worked as a financial analyst and distribution manager for a Fortune 500 company. Our second guest is a partner with the D.C. law firm of Tobin, O'Connor, and Ewing PC, where she focuses her practice on estate and trust planning and administration, probate, guardianship, nonprofit entities, real estate, and business law. She is also a member of the D.C. Superior Court's Fiduciary Panel and also accepts court appointments in guardianship and estate matters. And she is co-chair of the steering committee for the Estates, Trust, and Probate section of the D.C. Bar. Please welcome back D.C. attorneys Ray Johnson and Jennifer Casino. Guys, welcome back.
Thank you.
We learned a lot in that first show, and we still got a lot to cover. Mm-hmm. So I appreciate you guys taking the time to share some of your expertise with us. Jennifer, let's talk about, we have all this process, whether we're a standard probate or abbreviated probate. There's certain things that you generally want to do as you wrap up the estate. Talk a little bit about some of the things that, let's talk about the time frame again, and sort of remind folks about the time frame to wrap up these estates.
So if it's an unsupervised abbreviated estate, it can usually be wrapped up as early as 6 months, but as late as a year.
Okay.
And what needs to be done is make sure that you pay the creditors first. Mm-hmm. So we always tell our beneficiaries they're last in line, and they don't like that. But that's very important. So before that is going to be paying the taxes, paying the bills, paying expenses, paying fees. Mm-hmm. And then make the distributions. Okay. You typically have a beneficiary sign a receipt. Okay. And those receipts, if it's unsupervised, need to be kept in your file. If it's a supervised estate, those will need to be filed with the final account, demonstrating that the beneficiaries have received what they're entitled to get.
That's your documentation.
Yes.
Okay. Now, tax clearances. As part of wrapping up the estate, what do you recommend folks do in order to make sure that the taxes are paid? Anything specific?
Yes. So the estate tax, I don't want to get into the weeds, but
no, of course not.
And when you do your final account, they will want to see a closing letter or some sort of statement that the taxes have been paid. Okay. So you definitely have IRS forms also that should be filed to make sure that the decedent didn't miss any tax years as well. Sure.
And we certainly encourage folks to get tax transcripts, make sure all those, so you can see that they actually filed the tax returns and then get those filed just so you know that's done. How about, do you do anything in the way of refunding agreements of any kind?
In DC, we do not.
Okay.
I don't know about Ray.
You want to explain
No.
what I'm talking about? I didn't want to jump ahead, but sometimes we give money to the beneficiaries. We think everything's been paid, but then something shows up that, even though notwithstanding our best efforts, something shows up that needs to be dealt with. How do we deal with that?
So I practiced in Pennsylvania my first few years out, and we regularly did refunding agreements. I don't know why in DC that's not a regular practice. Some people might do it.
Okay.
But I think it's because we run into an issue that once the money's been paid, it's probably going to be very hard to retrieve.
Sure.
So it might not be worth the ink on the paper kind
Okay.
of idea, a practical issue rather than a legal one.
Okay. Okay. And then let's just again reiterate the process to pay bequests of property and legacies. What we want to get written receipts so we can document that.
Yes, you have to have the written receipts.
Okay. Okay. Ray, let's talk about something that, someone's serving as a personal representative, whether it's an intestate or a testate. They think that they're entitled to some compensation because they're doing some work. How is compensation determined?
Well, compensation is purely determined in terms of reasonableness. They're not required to receive compensation. Sometimes the will have that in its language about the PR being compensated. And typically, if it's a non-professional, what's deemed as reasonable by the DC Superior Court is about $25 an hour.
Okay.
Now, I use the word per hour, so it's very important that you keep account of your time and keep account of your work. Because although it may be abbreviated and unsupervised, lo and behold, if it becomes supervised, it will be supervised. It will be analyzed and looked at. And so you must be diligent in terms of your timing and your accounting and your reasonableness. Now also, typically, you might have to hire an attorney. And so if you have an attorney, his compensation would be, quote unquote, need to be reasonable. But typically an attorney's billable hours is typically accepted if the assets are sufficient for paying. So the main thing is just have it reasonable, keep diligent time, and keep good accounting records of what you're doing for the estate.
And if an attorney is serving as the fiduciary, do they simply then bill on their hourly rate? That's how that works in the
Yes,
District of Columbia?
if it's a solvent estate, yes.
Okay. Okay. And I think that one of the real challenges for lay people, of course, is the idea of recording your time and keeping track of your time. But that would include everything, traveling down to the house, packing stuff up, going to the post office to do this or do that.
Yes.
It includes all of that stuff.
It includes everything. If you want to be paid for it, you should account for it.
Okay.
So it essentially does include everything.
And you would submit that accounting of your time with your claim.
You would submit that accounting of your time with your account and showing that you've paid it, and if you are going to pay it, and what's the support of the amount that you're paying for that.
And I'm just curious, would you seek out the approval of the beneficiaries of the accounting and your fees before you did that, typically?
In terms of compensation, I may typically ask for that, but no. Essentially, what you do is you would, once you file your accounting, which shows the compensation, shows the support documents, they have 30 days, correct? 30 days in order to object or approve or not even respond to the account that's been filed or submitted to them.
Okay.
But if they do object, they will go to the court and make that objection.
Okay.
So even if it's an unsupervised estate where you don't have a duty to file your final account, you're still going to send it to the beneficiary, and they can still file an objection even though that account hasn't been filed yet with the court.
Right. So that's where it could possibly then convert itself from an unsupervised to supervised because of that issue possibly.
Or maybe just on that issue.
On that issue alone.
Yes.
Okay. Okay. Well, that's a good set of protections for the beneficiaries, though. So that's a good.
It is.
Let's talk about Jennifer. Let's turn to you again and talk a little bit about common problems. Okay. What are some of the common problems that arise in the administration of an estate that you've seen?
So the big ones to me are not handling the creditor claims properly, especially ones from people who had received Medicaid coverage And then they
Oh,
have
yeah.
a house that needs to be sold.
So they have to repay their Medicaid, they repay some money.
Repay the Medicaid lien, and beneficiaries are shocked at the amount of money that might be, that is going to be against the house, which might not have any mortgage, have a lot of equity.
Oh my.
Also, the problem sometimes is that distributions are made too quickly, meaning before the 6 months claim period. We have personal representatives that want to do everything so fast, and you have to say, slow down. There's a 6 months claim period. If you distribute too soon, you're personally on the line for that money.
Absolutely.
So
We'll be careful about that.
we talked earlier about protecting real estate. That's another problem we see occasionally. Dealing with mortgage companies. If there's a mortgage on that property, you have to make sure that the mortgage is paid, or speak to the mortgage company and let them know that the property is listed for sale in order for them not to start foreclosure proceedings. And then we talked about this earlier, communication. Keep those heirs and beneficiaries informed of what is going on. The personal representative might be doing everything right to the book, but if the heirs think something's going on because it's taking too long, they're going to file something with the court and cause a lot more expense and issues that need to be dealt with.
Okay. Do you find that it's also an issue for people not reaching out and getting professional advice early in the process?
Yes. Like I said earlier, DC is very good about pro se litigants. However, there's times when you really do need an attorney, and dealing with a lot of money and a lot of issues, you should have professional advice.
Okay. Yes. Well, that really leads us to one of the topic areas we talked about when we were preparing for this show, where you really do need professional advice, and that is where you have one of the biggest assets that you had mentioned, Jennifer, is in a state typically is the real estate. And someone dies with occupied real estate. Tell me, Ray, who actually owns that property at that point?
When someone dies that's occupied with a tenant and or an unauthorized occupant, the estate owns that property.
Okay.
And essentially has to deal with that occupant. And at times, there was what's called, if you want to, let's say, sell that asset with that occupant, there was at one time for a single family home a law called TOPA, which is the Tenant Opportunity to Purchase Act. And essentially that says that if that person is a tenant, he has rights of first refusal on purchasing that property. So that's to say if that estate has an apartment building or something of that nature, not a single family residence which has been exempted, then they have to deal with that TOPA.
Okay.
But they are essentially stepping into the shoes of the decedent, and the estate will own the property. It's going to be titled in the name of the estate.
Do you normally suggest that people have a title search done on that property to figure out what's going on this before you get too far out of the gate?
That's very important. I've learned that's very important because not only do you want to see if there's any title issues with the property, but you want to also identify if there's any recorded liens with the property.
It's interesting how those liens, you may not even know they've been recorded.
Yes, yes. Especially if you, for court-appointed fiduciaries, we may pick up, like me for instance, I picked up a property where a guy died in 1985. And so there was several liens out there in regards to not being identified initially, but came up in a title search.
Okay,
so that's very important.
So that's a good thing to think about doing. There are some limitations on the ability of the personal representative, potentially, to sell real estate that might be in an estate due to the fact they've got to go through these hoops. Now, is there any pending legislation to deal with the single-family residence that exempts it from TOPA now?
Yes, as I mentioned, there's pending legislation to exempt the single-family residence out of TOPA. Before that, all properties, whether it had an occupant or not, had to first identify was there a legitimate tenant, and if they were, then they did have to deal with TOPA regardless of what the asset was. But now the DC Council has made an exemption for single-family residents in that respect. Yes,
I think it's a real good move. Well, we talked about, you mentioned mortgages, Jennifer. I know a lot of people nowadays, and there's been some recent changes with the thing called reverse mortgages, so you're seeing a lot more people being attracted to and using reverse mortgages. Talk about the impact of a reverse mortgage in an estate when someone passes away? What do we need to be worried about? What do we need to deal with?
Well, typically, when somebody acquires a reverse mortgage, part of the mortgage agreement states that if they pass away, the mortgage has to be paid in full within 1 year, is typically the time period. And personal representatives and heirs don't realize that. They might have been living with mom or dad in the house and think, well, this is the family home.
Right.
So
right.
I'm not leaving. And if they don't do something, then something's going to happen to them.
That's true.
And that something would be a foreclosure action. And it's interesting because a lot of the cases that Ray and I are appointed as personal representatives by the court are these reverse mortgage cases where the family did nothing. And the lender institutes foreclosure, but they need somebody to sue. So they also, at the same time, ask that the Register of Wills appoint somebody from the fiduciary panel as the personal representative.
Sure.
So basically, we're just there to accept service on the foreclosure.
Yikes.
Although we typically try to sell the properties, and I've been successful in selling the properties and still getting a little bit of money left for the heirs.
That's important.
Very important.
That's important. But if it's not paid off, they run that risk. I think that's one of the things that's important about doing the title search. You know, if you're not aware and you're not familiar with the family dynamics and what their finances were, that would be disclosed in that title search. And of course, one of the key things that a personal representative needs to do, of course, is begin to change the mailing address where the mail goes, and that'll also tell you some things. You'll start to get those notices and realize you may need to call somebody.
I call that forensic mailing.
Yes, it's the easiest thing you can possibly do, but boy, you get a lot of information.
And that's important in regards to if you have someone that dies and there's no one at the property, you probably still have utilities that's going on. So you really want to identify if there's any utility bills or any notices from the city that they might come to the house, that you want that mail forwarded to your location. So you can be aware of everything that's going on with the asset.
Well, and in DC, the water company has automatic liens against the property. So the title search will show that if the city has placed a lien on the property. One more issue with real estate is if the property is vacant, it runs the risk of having a higher real estate tax assessment.
Oh, really?
It would be at 10% of the value.
Oh, my goodness.
If it's a vacant, blighted property. One of those properties where the grass hasn't been mowed and the windows are broken and a door is half open.
Huh. Interesting.
So it's very important to deal with that property as soon as possible.
That's true. We don't want to add to the cost. We need to take a couple of quick things. I want to talk about professionals real quickly, Ray. Professionals are being hired to help out the estate. Tell me, is it really important to get that professional involved early?
I think it's very important. If you're not utilizing an attorney, I would say yes, it's important to use it as an attorney from the outset, so that he doesn't have to go back and make up anything or correct anything. But in addition to attorney, you have the accountants who must do the account properly if you don't have the knowledge to do so. The appraisers, the real property appraisers, and the personal property appraisers. Because you remember what we said in the beginning, you have to marshal the assets and then show an inventory of those. So you want those properly valued. And then last but not least, if you're trying to sell the property, you want a professional real estate agent. Me as a personal representative, I don't want to own the property and have to go through the, responsibilities of marketing and doing the real estate. So you need a real estate agent in order to make that happen very smoothly, because that's their profession.
I know when we were preparing for the show, you folks had mentioned that most people will hire a lawyer, to help with the administration of the estate. But we want to reiterate that. I think if those folks who think they want to do it yourself, and there's a whole generation that believes in doing it yourself, that may not be the best course of action.
I was going to say, we have people that start it, but we usually get a lot of clients that end up calling us in the middle and saying, help.
Right.
And so I think everybody, if they don't start with an attorney, ends up with an attorney.
And keep in mind, the attorney doesn't have to do everything, but they certainly can guide you and say, okay, here's a pothole you need to watch out for, and here's things you can do yourself, because there are some things that the lay person can go ahead and do.
One thing that Jennifer mentioned at the end of the last program is DC Superior Court has what's called a resource center. So some person may want to take advantage of that and understand why they need an attorney. So in other words, on Tuesdays of every week, this resource center is open to the public. I think you're allowed to come down, you sign up, and then you can talk to an attorney about the pitfalls and the details and the requirements of probate administration. And I think that's an opportunity for them to find out, yeah, this is bigger than what I can handle, and I think I need an attorney to help me guide me through this.
That's a tremendous resource. That's a very good idea. Well, let's jump into, for the last 3 or 4 minutes here, let's talk about some sample probate cases and kind of see how these things play out in real life. Because the typical estate, just for our purposes of our discussion, we have a piece of real estate, residence, single-family home. We have a bank account of some kind. We have a life insurance policy which has a beneficiary of some kind, and then we have a retirement account with a beneficiary. So let's take a look at those and take a look at our first case, which is married couple dies, spouse dies with the will. What are we going to happen? What's going to happen with this probate estate typically?
Well, typically, as far as the real estate is concerned, I think that's going to automatically transfer to the surviving spouse, because typically a married couple will have what's called tenants by the entirety with right of survivorship.
Okay.
So you may not need, or you will not need to probate that estate, because it's going to automatically happen. And that's probably also for bank accounts if they are joint accounts.
Okay.
Those will automatically go to the spouse. Now, if you have an account that's a single account in that descendant's name only, then you may have to probate if that administration in order to get authorization to control that account.
In case of the life insurance and the retirement accounts, what would you see would happen there?
Typically what drives the life insurance is the beneficiary. They may fall outside of the estate's administration because that has a name and beneficiary, and those funds will go directly to that.
Okay.
In retirement accounts may be the same way. If it has an identified beneficiary, it may fall outside of the administration of the estate and go directly to that beneficiary.
Okay. Okay. Well, Jennifer, let's take the second case. Same set of facts. We have real estate, bank account, life insurance, and a retirement account. So the widow dies now with a will, and she's survived by the children from the marriage of the husband who passed away. How does that estate get probated?
Well, that would typically be an abbreviated, unsupervised probate, which in my opinion is the simplest probate in DC. The will would name a personal representative. That person would file the will, file the forms to start the probate process, and then begin the process we spoke about, marshaling the assets, paying the bills, making sure everything's protected. If there was a house, the house would need to have insurance and make sure the utilities are paid.
Sure.
The beneficiaries could talk with the personal representative about maybe transferring the house to the heirs if they want to keep it and rent it.
Sure.
Or if they want to sell it, the personal representative can sell it to pay debts and expenses.
Sure.
Life insurance and retirement accounts typically have beneficiary designations, but if not, those would flow through the estate and have to be administered just as any other asset. Same with the bank account. If the account was just in the name of mom, then the personal representative would go down to the bank with their letter and say, I'm the PR. They would open an estate account and then administer and pay the bills from that account.
Okay. Okay, let's go quickly to the last one here, which is single person dies with no will, has a house, has a bank account, has life insurance, has a retirement account. How does that play out in DC probate typically?
Well, typically that turns out to be a standard probate, because typically if a single person dies with no will and they have real estate, that implies that that mortgage is not being paid, and therefore the lender will more than likely initiate a foreclosure action in order to satisfy that. And because the lender is not a direct heir and or beneficiary to the decedent, he will have to go the standard probate route, as Jenna mentioned, have a PR appointed to serve, and then that PR that's appointed to serve would just do as any other probate PR appointment would occur. But that essentially goes under standard because that is not a direct beneficial heir of the decedent.
Excellent. Well, we're running out of time, I'm sorry to say, but guys, thanks again so much for coming and participating in the first show and sharing that, and then coming back and helping us kind of work our way through to the end for the DC probate process. It's been great, and it's going to be a great resource for the folks in the District of Columbia. So thank you for your great public service.
Thank you for having
us.
It's been my pleasure. Without a doubt, probate can be complicated and confusing. Over the course of 2 shows, our guests have given us an excellent introduction to the DC probate process. They discussed the types of probate available, the role of the DC Register of Wills throughout the probate train pride, from the time you're legally qualified to act to when you distribute all the assets to the beneficiary and close the estate. They also highlighted important duties and deadlines to keep in mind during the course of your journey. And they took all this information and applied it to some typical estates so you could see how it all fits together. Be sure to also check out all those useful guides and forms and checklists available online from the DC Register of Wills. They have a very robust website that you will find useful. Collectively, these resources and the insights shared by our guests in Part 1 and Part 2 should make your DC probate train ride go a bit more smoothly. This brings us to the conclusion of our show today on the overview of DC Probate Part 2. I hope you found these shows as informative as I did, and remember that replays of these shows can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.